call to order. And before I proceed, let me directly with the Secretary to Advisors. Good morning, Your Honors. For today's hearing, we have the following resource person. Present on site, our representatives from the Department of Finance, headed by Assistant Secretary Taxpayer. From the Bureau of Customs, Attorney Julito Doria. Present online or virtually are from the BAR, Deputy Commissioner Marisa O. Cabrera. From the Department of Justice, Undersecretary Raul Rastes. From the Department of Trade and Industry, Assistant Secretary Dominic Rentino Jr. From the National Privacy Commission, we have Attorney Vida Zora Bokar. From the Anti-Red Tape Authority, we have Director Rabindranath P. Kilana. From the Tax Management Association of the Philippines Incorporated, we have Attorney Julio D. Davilan, Suzette Felicius C., and Attorney Karina Laportet. From the Philippine Institute of Certified Public Accountants, we have Attorney Nelson M. Axted, Attorney Jesseline Briones, and Attorney Cherry E. Robles. And from the Philippine Chamber of Commerce and Industry, we have Attorney Carlos Caraco. That's all. Yeah.
Thank you, Mr. Secretary. Once again, morning to everyone. Maraming salamat po sa inyong participation. And thank you very much for your presence, both virtually and physically. Let me put emphasis on the physical presence of DOF. Malapit lang naman kayo, so okay lang yan. And DOC, malapit rin kayo dito, kaya okay lang yun. But today we'll be tackling two bills. This is Senate Bill number 1077, entitled "An Act to Define and Protect the Rights of Taxpayers," authored by the Pinuno of the Senate, Senator Rico Lapid, and Senate Bill number 1199, authored by yours truly. And let me just put on record that we also received notice that Senator Bong Revilla also filed a bill of the same topic, and it's still not referred. It's still being referred to this committee, so we will just consider that bill later on once we convene again. So let me just put that on record so that we will take note that there's another bill of the same topic. So today we'll be tackling the what we call the Bill of Rights and Obligations of the Taxpayer. And over the last 6 years, under the 7th and 18th Congress, there were 9 tax reform bills that were enacted by the previous administration. Let's give credit where credit is due. The previous administration carried the heavy burden of implementing tax reform, particularly the two major tax reforms, create and trade. And these tax reforms enabled government to collect additional revenue and raise its tax to GDP collection by about 14.5%, 0.5% shy of the World Bank prescription of 15% to achieve sustainable growth. So with those tax reform bills, we managed to improve our tax collection efficiency, almost probably far or even better here in ASEAN. So again, let's give credit where credit is due. The previous administration, headed by President Duterte and Secretary Dominguez, pushed for the massive overhaul and reform of our tax system. But this time, we'll give focus to the taxpayer. Outside of those 9 bills that reform our tax system, we have to refocus ourselves to the most important personality in the tax reform, the taxpayer. So this bill aims to give basic rights to our taxpayer. Although these basic rights are already somehow present in various laws, various issuances, even our constitution. So the aim of this bill is to codify, to put all of those different rights and different obligations of the taxpayer in one single law. In fact, based on our research, if you look at the proposed bills, there are only three new concepts outside of the existing rights and obligation contained in various laws and instrumences. So, we want to make it easier for your taxpayer. So we're now putting it in one bill, codifying it, updating it, and make it easier for our taxpayers to understand their basic rights and their obligations as well. So today we'll be tackling these two proposed measures, and we request our panel of experts to give your opinion, to give suggestions. Um, Please bear in mind, when I say taxpayer, lahat po dito sa mga, lahat po dito sa source persons, even in this room, are considered taxpayer. Lahat po tayo, apektado po nitong batas na ito. And all of us are the beneficiaries of these two proposed measures. So feel free to suggest and to comment on the bill. This is a working process, so we'll be undertaking a technical working group after this hearing to refine the bill further. So with that, before I continue, let me acknowledge the presence of Senator Nancy Binay.
Good morning, Mr. Chairman.
Good morning, Senator Nancy. Any opening remarks?
None, Mr. Chairman. We can proceed with the presentation. Thank you.
Thank you, Senator Nancy. With that, we'll start off with the government agencies. We want to hear the comment of our government agencies. We'll start off with the agency that is primarily responsible for collecting revenue and also interacting with our taxpayers. We call on the DOF for their comments on the proposed measure.
Thank you and good morning, Mr. Chair. Pleasant morning as well to our Honorable Senator Binay, other members of the Senate Ways and Means Committee, also to the resource persons joining this committee hearing via Zoom. The Department of Finance is supportive of proposed measures which aim to promote transparency, taxpayer protection, and support taxpayer advocacy, particularly on MSMEs, which the two Senate bills, namely Senate Bill 1199 and Act Relating Bill of Senate Bill number 1077 and Act to define and protect rights of taxpayers are functioning. The DOF would like to prefer, however, a simplified Bill of Rights and Obligations. This allows for flexibility in its application. The aim for the creation of a taxpayer's Bill of Rights is not to build a wall between taxpayers and tax administrators. In fact, it is instituted so that taxpayers would have confidence in the fairness, equity, which the tax system provides. We note and support the inclusion of taxpayer duties and responsibilities in Bill number 1199, which I think is the only version of bills in both houses that outline as well the obligations of taxpayers vis-a-vis their rights. This is in accord with the suggestion of the OECD, also find advocate Francis and IBFD or the International Documentation. Lastly, any penalty that will be imposed on violation of any right should be commensurate to the right violated. As to the creation of the National Tax Advocate Office as guardian of the taxpayers' Bill of Rights, we note that this is a novel concept in risk taxation. Insofar as it ensures taxpayers' welfare and protection, the DOF welcomes the same. We would like to work closely with the Committee on Ways and Means Senate, the House, to ensure that the proposed roles of the National Tax Advocate Office will be harmonious with the existing structures that we have. And also for said office, to perform its functions as desired in the proposed. Thank you for your time.
Thank you, Aztec. Before I throw my questions, let us finish with the other revenue collecting agencies that we have a full view of the position of DOF revenue collection agency. So we call on BIR for their comments on the measure.
Ito. May ano pa. Good morning. Ano ba tayo?
Good morning.
Yes. Good morning, Your Honor. I am Deputy Commissioner Marisa Cabreros from the Bureau of Internal Revenue. The Bureau supports the institutionalization of a taxpayer's bill of rights, which will serve as guiding principle in formulating tax policies and to increase taxpayers' awareness of their rights and protection. In this regard, while the rights granted to taxpayers in the proposed bill are generally provided in the 1997 Constitution, in the Tax Code, Data Revised Rules of Court, Executive Order Number 2 on operationalizing freedom of information under the executive branch and other related laws, the Bureau believes that these rights should be consolidated for the benefit of taxpayers and the BIR and other government agencies. The ordaining of a taxpayer's Bill of Rights will strengthen the efficiency and collection efforts of the BIR and the BOC, since taxpayers will have confidence and trust in dealing with said government agency. Also, the Bureau supports the establishment of the Micro and Small Taxpayer Clinic, or MSTC, program to assist our small taxpayers in audit, appeals, and tax collection dispute. However, it must be ensured that such taxpayers are properly classified and registered as micro and small taxpayers. Moreover, the proposed bills create additional expenditure for the government, considering the hefty capital needed for the establishment of the Office of the National Taxpayers Advocate and its respective offices. Sorry, sir. The Bureau, however, with due respect, sir, opposes the creation of the Office of the National Taxpayer Advocate because it merely transfers most of the powers of the BIR to the National Taxpayer, and that powers and authorities given to it merely duplicate those being exercised by the CTA and the regular courts, as if I may, as discussed as follows. First, the Bureau is headed by a Commissioner of Internal Revenue, and it's a government agency tasked with assessment and collection of all internal revenue tax fees and charges, including enforcement of all forfeitures, penalties, and fines connected with the violations of the tax code. We also execute judgment in all cases in favor of as an assist to the Court of Tax Appeals and other ordinary courts. We also have, we effect and administer the supervisory and police powers conferred upon us in the tax code and other special law. Necessarily included in the provision is the assistance to taxpayers. Currently, there is a client support service office in the national office, as well as client support sections in all revenue district offices, whose mandate is to cater to the needs of the taxpayers, including taxpayers' information, education, recording, update and registration process systems improvement, design, revision, and review of external forms and internal-external stakeholders' communications, and customers' assistance, all with the end of improving taxpayer satisfaction in the process in the Bureau. Second, the tax code provides taxpayers administrative judicial remedies before and after payment of relevant taxes. The remedies before payment of taxes consist of administrative remedy and judicial remedy. The remedy of payment of taxes is availed of by paying the assessed taxes within 30 days from receipt of assessment and the filing of claim for refund or tax credit with the commissioner of the Bureau on the grounds that they are erroneously paid within 2 years from the date of payment. Should there be a denial or inaction with prescribed period, the taxpayer may appeal to the Court of Tax Appeal. Moreover, the power and authorities given to the Office of National Tax Advocate, such as power to issue stay order, which may include suspending the assessment and collection of taxpayer, a taxpayer's assistance order, and to cite contempt revenue customs officials and employees might merely duplicate those being already exercised by the Court of Tax Appeals and other regular courts. The CTA and the regular court are actively using and exercising these powers in accordance with the rules and invocation by taxpayers or party to the case. Lastly, the Bureau humbly submits that the provision of the proposed bill, insofar as it requires the Office of the National Tax Advocate, a potential executive agency, to report to the legislative branch once a year, might violate the separation of powers as instituted in the Constitution. This might involve, but however, sir, we note that we adhere to the position that will be taken by the Department of Finance as our supervising principals. Thank you, Your Honor.
Thank you. Thank you, Deputy Commissioner. We'll get back to you again for questions. We'll hear the other revenue collecting agency so that we'll have a full view of the position of government. So we'll call on the department, the Bureau of Customs. Good morning, Your Honor. For the Bureau of Customs, we welcome most and particular issue of my another because provide down as has been taught open but than Jeff. With that, some questions. These are very basic elements of Treasurer. First to the DOF. I've heard from BIR, from Cabarrios, that some of the concepts here measure are really various laws and see that I want. So do you see the need and merit define all of these uh, different field of rights once you know? And next question, how will it help the department of the taxpayer if by your opinion? The third question.
Mr. Chair, as mentioned, well, it's that. Since the but given that or taking time, giving out MSPs, and I think this is a way that's the cooperative help with it. So anything that will improve that, that's as a mentioned, we have forms, specs, or functions, see, sort of enhance the powers, broadens uh, that role. I think it is one important system that very important in thinking and improving tax. Thank you.
So how do you keep the uh, improve first one? How do you see this helping the DOF collection? Of course, it is you know through the bill. This is specifically aimed at the taxpayer, but this is also um, the an effect to the collection of taxes.
One of the intentions of GPT's section is taxpayers information presentation, taxpayers education, and I think it should be put in process assisting the taxpayers how to comply because part of uh, it will be also have that time.
As you mentioned earlier, that uh, uh, brief debts uh, the tax bill of rights proposal uh, on into on your day-to-day activity upon by tax.
I think if you keep transparency part the as well as the assist in needs of the taxpayers. in their process. Like that is a way to build confidence in the tax authorities as well as the tax system.
Thank you for your suggestion on the tax advocate on the mobile. Well, in our country, it's mobile phone, but in other jurisdictions, one form or one term or the other type of New Zealand, Australia. So the concept of coming up with an office exclusively as taxpayers, not unique. To that po, I want to ask you, you mentioned that you oppose the national tax advocate. And you mentioned some reasons there. I just want to ask you, how do we make it palatable to the BIR? Because I understand that your opposition stemmed from possible overlapping powers, possible confusion between different agencies, different branches of government, particularly the. So how do you propose? Because the objective of the national tax advocate is to help national tax, the taxpayer, para siyang power uh, of the taxpayer. No, but admittedly, we still need to refine that. So how do you see adjusting, no, the proposed national tax advocate so that it will not encroach on existing duties and responsibilities? However, it will still fulfill uh, its proposed mandate to help the taxpayer in times of, let's say, conflict, or in times of, when they need help, specifically on their assessments. So how do you see so that a structure so that there will be no conflict?
Okay. Yeah. Yes.
Let's go ahead, Repcom.
Yes. Sorry for we're having difficulty. Wait, sir. Sir, with reference to your question, with due respect, we are just worried with the creation of a separate office, the National Tax Office, because of the potential duplication of functions, which is being exercised by the BIR. However,
Repcom, medyo there's an echo. Um, I think there's a computer also listening in your office. Pwede paki-mute na lang po yung ibang computer.
okay, sir, can we try?
Yan. Yan, better.
Okay, sir. Pero meron
Meron pa rin eh. I think it's from your office. I think there's some people in your office who are also listening to the hearing. They can just turn their microphones off. Dalawa yata yung device dyan ho sa inyo.
Hello? I-log off mo na yung isa para
Yan, better. Repcom, mas malinaw na.
Okay. Yes, sir. Sorry for the technical issue. The BIR is just of a position that the creation of a national tax office will indeed have a duplication in the function and work, which is actually being performed currently by the BIR. But we adhere to the statement earlier of the Department of Finance that to oversee compliance with protecting taxpayers' rights and protection, there's an established mechanism right now in the tax code where we report before the joint oversight of Senate and Congress. We can abide by reporting to the oversight committee in checking all these matters that will be intended to be placed and monitored by a taxpayers advocate office.
You mentioned earlier, DepCon, may na-mention kayo yung mga duplication of responsibilities between the advocate and BIR itself. Can you name those duplications? And do you also propose to remove those duplications in the law so that boundaries will be clear? We're open to that. No, what we want is ako rin personally, I don't want duplication and because duplication will lead to confusion. No? So we don't want that to happen. No.
Yes, yes, sir. With due respect, we do embedded in the organizational structure of the BIR is an office called the Client Support Service, which is basically tasked in administering frontline services to our taxpayers. And in the respective revenue district offices, we do have a client support sections that supports the entire national office client support service. So that at that aspect, there is a potential duplication of work because it is already embedded in the structure of the BIR, the monitoring of protection of taxpayers' rights and obligation. And then moreover, the proposal indicates an authority to be given to the National Tax Advocate to issue a stay order. A stay order means suspending assessment and collection of taxes, which go which are not aligned actually with the lifeblood theory of the existence of the government. That's why we are covered already by the provisions of the Court of Tax Appeals that they are the ones authorized to issue injunctions against the BIR whenever the subject matter involves collection of taxes. So on that aspect, sir, there might be a duplication of what is being exercised already by the Court of Tax Appeals with reference to preventing BIR from pursuing assessment and collections.
DepCom, let me break down your comments. No, first is the client support service. Um, this is existing already inside BIR.
Yes, sir.
What type of service is this office giving to our taxpayers?
The client support service offers frontline services to our taxpayers. So they give assistance in registration, um, information dissemination, giving education to our taxpayers. And the policy definition or structure is being defined here at the national office through the client support service at the national office. The actual implementation of monitoring and assisting our taxpayers is being actually implemented in frontline in every revenue district offices through the client support sections of our RDOs.
Well, I commend BIR. No, I've been going through your website quite often lately because of my chairmanship, and I commend BIR for really making an effort to educate our taxpayers as well as making it easier for them to report anomalies and also complaints. No, and I commend BIR for doing so. In fact, the response time we also documented it. It's quite it can be improved, no, but at least there's my response po. No, so um, I understand that this client support service, its primary job is to assist the taxpayer. What about if the taxpayer will have disputes? What about the taxpayers will have
questions on the assessment itself. Meron ba hong ganong service na binibigay ang client support service? Is there such a mechanism for, is there a redress mechanism for taxpayers?
First, sir, with reference to the assessment process, there is a defined rule already in the procedures that the taxpayer should follow when it comes to protesting or assessing, disputing an assessment against them. So there is a due process definition which is embodied in a revenue regulation. However, if the taxpayer still wants to complain or report some hearing personnel or they feel that they are not being treated properly, there is also a mechanism of reporting to the National Office of hearing personnels. In fact, they can openly write the commissioner a letter about it, or if they want an anonymous letter, or through the website, where in the website there are e-services there which would enable them to report to the attention of the national office if there are complaints from the taxpayers.
Depcom, can you explain further the due process for assessment? Because that's one of the, if you look at the powers of the advocate, that's one of the core functions, no? And I think that's also one of the contentions of BIR, no? That those powers might encroach with existing offices right now. So can you walk us through, for an ordinary taxpayer? For example, there's an assessment dispute. What is the due process mechanism for the taxpayer?
Sir, first is I'd like to point out in the tax code section 4, the main reference of the authority of the commissioner, the power of the commissioner to interpret tax laws and decide on tax cases. So the commissioner has exclusive and original jurisdiction over deciding on disputes and assessments against the taxpayer. But the due process cycle for an assessment starts with first voluntary on the part of the taxpayer. Since our tax system is based on self-declaration, they are to file a return. Okay, so it starts with filing a return. However, even absence of actual filing of the return, the BIR can still subject a particular taxpayer to audit. So auditing starts with issuance of a letter of authority. The letter of authority is being given to a subjected taxpayer, informing them that they are to be investigated on their books of accounts for a particular period in a particular tax type. Normally, if it says AIRT, it means all internal revenue taxes. Once a letter of authority has been served to our taxpayer, the taxpayer is supposed to prepare their books of accounts, the supporting documents for that particular taxable year for them to be audited. If they refuse to present their books of accounts, the tax code is also equipped with power for the commissioner to issue a subpoena to compel the taxpayer to present their books of accounts. If the books of accounts have been presented and audit has been properly conducted by our revenue officer, the next steps are the revenue officer is to issue a notice of discrepancy, meaning they are to inform our taxpayer of the discrepancies that they have discovered in the course of auditing. This will enable the taxpayer to look into those discrepancies. The discrepancies not necessarily would amount to deficiency taxes, but rather these are areas where there are discrepancies or cannot be reconciled by our examiners. After giving time to our taxpayers to explain what are those discrepancies, the examiners is supposed to issue a preliminary assessment notice. The preliminary assessment notice is a notice to it's a letter informing our taxpayers of the resulting deficiency taxes because of the unexplained discrepancies. They are given 15 days to answer and respond to a preliminary assessment notice. Thereafter, the next step is the BR will issue a final assessment notice together with a formal letter of demand, informing them that this is the X amount of liability that has been discovered, but a formal assessment notice should, to be valid, should contain statement of facts upon which the computation has been made, and statement of law and basis in law why those particular assessment is assessable against our taxpayer. Then thereafter, the taxpayer under Section 228 of the Tax Code has the right to protest, formally protest the assessment, the final assessment notice. They are given 30 days to protest the assessment. Two forms of protesting the assessment. They could either file a request for investigation or a request for reconsideration. If it's a request for reconsideration, it's like saying they are telling the BIR, can you look into the computation again? Maybe there is an error or a misappreciation of how it was computed against us. A request for reinvestigation is saying and telling the BIR, can you look into the computation again because there are documents or newly discovered evidences that the taxpayer is offering the BIR and presenting to the BIR to merit revisiting of the assessment. The difference of the two, sir, is request for reinvestigation. There is an expectation of submission of additional documents to be presented to the BIR within 60 days from the protest. Otherwise, the assessment becomes final and executory. And then after the protest, the BIR will issue a formal final decision on the disputed assessment where the taxpayer, last ditch, can file an MR to the commissioner or can decide to go up and file a case before the CTA to question the assessment being made by the BIR. All these steps, sir, is drawn up in a revenue regulation as guidance to our taxpayers on the entire assessment cycle, sir.
So thank you for that comprehensive step-by-step procedure. What if I think the objective of the National Tax Advocate is to help those who are not equipped with legal support. For example, you're just a small, let's say you're an entrepreneur, no? A single proprietor entrepreneur. Meron kang one or two outlets, maybe food or beauty outlets. Not all of these taxpayers have access to lawyers and to full-time certified public accountants. So the vision for the advocate is to help this type of taxpayers, those who are not equipped in following the process that you mentioned. No? Your process is quite rigorous. Maraming terminologies like letter of authority, may subpoena pa, may mga preliminary assessment notice. Si Juan de la Cruz, hindi ho maintindihan ho ito eh. No? And I am very, very sure, no? A lot of our taxpayers, because when I was a mayor, I used to talk to them a lot, no? Hindi nila kabisado yung ganitong process, no? And these are, I know that the BIR is really exerting effort to make it easier and to make it understandable. But not, admittedly, not all of our constituents are equipped to understand this type of process. So the objective of the advocate is to really target those market, not the ones who can hire lawyers and accountants, no? Because obviously they have the capability. So that's really the objective of this advocate. But I see your point, no? That meron namang ganitong very strict and rigorous process, and the stay order and the powers that are given by law to the advocate might slow down, no, or hamper the tax collecting process, no, even hamper the due process. So, DepCom, if we trim down the or harmonize the powers of the advocate to purely assistance, purely advice, will that be palatable to the BIR? Kasi nga yung stay order, parang quasi-judicial na nga siya. Kasi pag nag-issue ka ng stay order, hinto lahat eh. No? So, is that palatable? Kung purely advisory siya, counsel, advice, maybe a little bit of representation, but I'll ask DOF that, no? Is that going to be palatable to the BIR?
Sir, currently, the advocacy, there are a lot of private sector, and I see in the room a lot of tax practitioner. This is actually the current advocacy work of the different tax organization like PICPA, TMAP, that they are, or PCCI, that they are extending to the BIR for our small taxpayers. With your respect, sir, maybe as one idea is we can have the assistance to our small taxpayers within the bureau itself, or on matters which are involving legal already. Maybe we can tap the function of PAO, which is actually existing, and are also extending legal assist and work to our small indigent tax, which should include taxpayers. Or we could also have, in fact, there is an existing assist through the DTI. I don't know if they used to call it Go Negosyo, with the DTI, where the DTI is assisting the SMMEs with reference to their tax compliance and with the BIR rules and regulations.
Thank you, Repcom. Thank you for your again candid comments. Now, this bill is a working process. It's important for us to hear your candid comments so that we can process the information. We don't again, no. I am with you in terms of sustainable revenue collection. It's important. That's the lifeblood of our country that pays our salary and operates our government. But at the same time, we're balancing also the rights and the interests of the taxpayers. But thank you for that comment. I'll get back to you, Repcom, later on. We have a few more resource persons. But I want to ask BOC, Attorney Doria, this proposal, is this in line with the CMTA? I just want to ask you how this proposal will either strengthen or will either harmonize some of the taxpayer provisions in the CMTA.
Your Honor, insofar as the CMTA is concerned, there are already provisions that give essence to the right of the importers to question or to seek remedies insofar as the processing of the goods are concerned. Your Honor, insofar as taking a short glance of the proposed bills, the rights that are being propounded under these bills are also present under the CMTA, like request for ruling. Under the CMTA, we already have advanced ruling mechanism wherein the importer can, prior to the importation of the goods, can ask the Bureau of Customs to make a determination on what particular classification or valuation that have to be undertaken insofar as the importation of the goods are concerned. So they are also already given that right, Your Honor. Second, there is already a working professional customs brokers that we have, Your Honor. And the customs brokers are the ones that are already giving the importers the technical advice on how the importation or exportation of the goods are being undertaken. While the CMTA is no longer mandating the use of brokers, I think majority or 99% of our importers are still availing of the services of professional customs brokers, Your Honor. So they already have that advice that are necessary for them to process the goods. And the brokers are the ones who are, in fact, making the goods declaration. Third, Your Honor, um, there are already a similar mechanism also with the Bureau of Customs that are already being undertaken, such as the Customer Care Center. And we have already started the automation of our submission of the documents insofar as the processing of the goods are concerned. So right now, based on our existing regulation, importers are no longer required to proceed directly to the Bureau of Customs to process the goods, and they will just be submitting all the documents online, Your Honor. So um, just the same, there are already mechanisms also for redress of grievances insofar as the importers are concerned. They have the right to question the assessment or the findings of the examiners, Your Honor, insofar as the customs clearance are of the goods are concerned. So, uh, in essence, while this may not be uh, technically a duplication of the provisions of the CMTA, I go with the comment of Asek Napao that maybe it's also a good thing to put in place in a simple or codified document the specific rights and obligations of the importers. One is not necessarily to strengthen the rights that they already have under the law. Also with the agreement, as I mentioned earlier, the agreement on trade facilitation, but also to remind them of the responsibilities that they have to undertake insofar as the processing of the goods are concerned. So um, maybe, Your Honor, I would like to reiterate only that the function of the tax advocate will have to be really thought about, Your Honor.
Actually, that's my next question. What is your view, Attorney Doria, with the tax advocate? Because the tax advocate didn't make distinction between BOC and BIR, no? So,
Yes.
the vision here is to cover both. In fact, may mga proposals pa nga. Yung ba, DOF ba yun? Sa LGU? Who proposed it? Yeah, I think it was TMAP during the 18th Congress, wherein they proposed to include the LGUs, no? For obvious reasons, no? In fact, nung mayor po ako, we also collect taxes and we encounter a lot of assessment issues. In fact, baka mas madalas pa sa LGU, no? Because it's a micro level, no? So, I want to ask the views of BOC insofar as the proposal to create the advocate, the National Taxpayers Advocate. What's your view on that? Will the BOC benefit from that? Ano po yung inyong opinion?
Well, insofar as giving the additional opportunity of the importer to make further representation insofar as the goods processing of the goods are concerned, the tax advocate may be of value, Your Honor. Uh, Maybe we have to admit the fact that there are some concerns really that have to be addressed also immediately during the goods declaration, and maybe the intervention of tax advocate might help clear up some of the nuances or issues that have to be addressed, not necessarily by encroaching upon the rights of the district collectors, Your Honor, but just to make sure that the rights of the importers are also properly protected, Your Honor.
So the BOC sees no issue with the creation of this advocate.
Yes, Your Honor, except some of the functions which might be quite a challenge for us because even insofar as the processing of the goods are concerned, once the district collector issues the warrant of seizure and detention, not even the courts can intervene in the process. So
Dito kasi may stay order siya eh.
yes,
So,
yun
what's
yung-
your view on that, attorney? Anong tingin niyo? Again, oh, work in progress tong batas,
Yes,
ah.
yes.
So we're getting your opinion so that we can harmonize and make sure that hindi naman nating kiniklip no yung powers ng government. Marami rin naman taxpayer, alam naman natin maraming taxpayer rin na hindi rin maayos, no? So we also want to balance the powers of government so that government can do its job faithfully. No, so what's your view on that? Those powers that we gave to the advocate.
Well, insofar as the stay order is concerned, I think that's quite a challenge, Your Honor, because the proposed bill does not provide for a period within which that stay order is to be implemented, and it's quite different from the courts, Your Honor, because the RTC can only grant 20 days for TRO, and unless a preliminary injunction is issued, Your Honor. And the Court of Tax Appeals usually issues injunction for a period of 60 days. But insofar as the proposed function of the tax advocate is concerned, there's no period, Your Honor, and it might hamper the uh, the resolution of the cases which are supposedly designed to be facilitated, Your Honor, and the redress or the uh, mechanism by which appeals are to be undertaken are already provided for under the CMT, Your Honor. Specific periods are allowed within which the importer is given the right to file a necessary motion for reconsideration or elevate the matter to the Court of Tax Appeals, Your Honor.
So that will be a challenge. So do you suggest that we should remove that power? Again, the same question. Do we refocus the advocate to purely advisory, purely parang bibigay ng consultative body? What do you suggest, attorney?
Yes, Arna, I would tend to agree on the proposal to just maybe focus on assisting or giving further assistance to the importer, Your Honor, or the stakeholders, but not necessarily um, issuing orders that might hamper the functions of the Bureau of Customs, Your Honor.
Thank you, attorney. I have some more questions, no, but we'll go with we'll call on the other resource persons here, so that we'll hear their views on the matter. We'll call on the DOJ, no, because in our proposal, we will lodge this under the DOJ, no, and the reason for that is when I was the chairman of the Energy Committee, we visited Nevada to look at the setup of the regulatory body there. No, all utilities in the world undergo regulatory review by a specific regulator. In our case, ERC, but in their case, it's the I think Public Utility Commission. No, and meron silang energy advocate that represents the consumers. No, and we patterned that model and placed it here in this proposal. So instead of lodging the taxpayer advocate under the office of the president, we lodged it under the DOJ, no, to give it independence. And DOJ has some social functions, no, such as the Public Assistance Office and or the Public Attorney's Office, and that represents the marginalized. So the same concept in taxpayer advocate, we placed it under the DOJ so that the DOJ can represent the taxpayer who needs support. So we call on the DOJ for their comments so that we'll hear their views on the proposal. We call on Yusek Raul Vasquez.
Good morning, Mr. Chairman.
Morning po.
Esteemed members of this committee, guests, ladies and gentlemen. We welcome the proposal of the Senate through this bill to codify all the rights of a taxpayer. It is high time, we believe, Your Honor, that we focus on the side of the taxpayer and their rights relative to taxation. For a long time, the main focus had been on the tax collecting agencies being the source of revenue in the operations of our government, being the lifeblood of our governance. However, the proposal now makes things far easier, more expeditious, and inexpensive, at least for purposes of the taxpayer knowing what rights, what remedies available, and what recourses that they could avail of in order to protect themselves. We welcome the creation of a national taxpayers advocate because the concept of the national taxpayer advocate we submit, Your Honor, is an embodiment of the delicate balance of the state's authority to tax its nationals and its obligations under the Constitution and the limitations set under the law in respect to the rights of the taxpayers. We also agree wholeheartedly with the National Taxpayer Advocate, making it an independent body away from the tax collecting agencies under the Department of Finance, particularly the BIR and the BOC. We note, however, Your Honor, that there was we think that there may have been a mistake in not including other tax collecting agencies or entities like the LGUs, PESA, and the tourism infrastructure agencies or offices. We submit respectfully that the coverage of the law to include the other tax collecting agencies. We also note, Your Honor, that the rank granted under the bill to the National Taxpayer Advocate is just an undersecretary, and this could prove to be a problem in respect to the performance of its duties relative to the other national officials whose task is to collect taxes. We have been hearing with certain interest the comments from the BIR and the BOC in respect to a potential duplication of work or duties. But the potential duplication of work, Your Honor, is a bitter pill to swallow if only for the first time the rights of the taxpayer, especially the small taxpayers, be given prominence and importance. We believe, Your Honor, that the Senate, and we welcome the effort of the Senate on this regard, to put primary importance to the small taxpayers. We know for a fact that there are many big taxpayers who could avail of big name lawyers and law firms to protect themselves. And we Second, the comment of the Honorable Chairman regarding a single sole proprietor who may not have the luxury and the finances to do the same. This national tax advocate should be able to extend assistance, protection, and guidance to the small taxpayers. It being under the Department of Justice as proposed, which is different from the original contemplation before in the previous iterations or versions of this bill in the previous Congresses, which was to lodge it under the office of the President. Putting it under our department now may give it more immediate impact because if the actions of the tax collecting agencies may even amount to a crime, there is nothing that prevents us from assisting the national taxpayer advocate in initiating the necessary legal remedies on behalf of the hapless small taxpayers. But we do appreciate the concerns raised by the BIR and the BOC regarding the matter of the so-called power to stop the assessment. That could prove to be very sticky because even courts do have limitations in respect to that. Perhaps it may not be an absolutely necessary tool to make real, effective, and available the remedies to help the hapless taxpayers. It's not an absolute necessity, Your Honor, to give them that kind of a power. That we submit, but we defer to the wisdom of the Senate, and we also give due respect to the Department of Finance and its tax collecting agencies in respect to limiting the powers of the National Taxpayers Advocate. But we do believe that it has to be retained because it's high time that the rights of the small taxpayers be given importance this time. Thank you very much and good day.
Thank you. Thank you. Thank you, Yusek, for that um, very encouraging as well as candid comments. Indeed, the objective of this bill is to put focus on the taxpayer, no? Because for a very long time we sort of neglected the rights of our taxpayers, even though it's embodied in a lot of the bills, but it's a hodgepodge of provision to protect the rights of our taxpayers. I just have some comments. Well, first of all, my question on the National Tax Advocate being lodged under the DOJ as opposed to the OP. And you're correct, there were the previous iterations of this bill. The NTA or the advocate, National Tax Advocate, were lodged under the office of the president. But again, no, I saw some models in the US that this type of offices typically are lodged under the DOJ, no? Because the DOJ also has a function to service our constituents and also protect their legal rights. So, having said that, my only concern actually, Yusek, is the volume of request, volume of assistance. I remember nung mayor po ako, pagkausap ko po yung PAO namin, yung po isang PAO yata, 1,000 yung hawak na kaso eh. No? And I really sympathize with them because they really try very hard to represent their clients, especially the marginalized clients. But now it has improved dramatically. The case load of our PAO lawyers have gone down dramatically and their salaries have gone up dramatically as well, no? And that's good for the country. So my question for the DOJ is, because we're now catering to the small ordinary taxpayer, and this is a lot, no? If you talk about MSMEs, I think that's about 900,000, no, close to a million MSMEs. I just want to pick your brains on the potential volume of taxpayers that will seek advice, seek assistance from the DOJ through the National Tax Advocate.
Your Honor, Mr. Chairman, we are all public servants, so we are not allergic or we are not fretting away from that challenge. It would certainly be a big load that would be carried by the department, but we are happy to inform this honorable body that the DOJ is continuing in its effort to improve the number of its personnel, the prosecution staff, the fiscals, the public attorney's office, in order to be able to stand up to the challenges brought about by the needs and request for assistance from our citizens. The department is also nationwide, so it will certainly be able to address all that, especially if the NTA, as contemplated under the law, will also have its local offices. It's just a matter of fine tuning the IIR, I suppose, the implementing rules and regulations, so as not to be facing a deluge day in, day out in respect to that. Presently, and I'm happy to inform this honorable body about the institutional reforms that the present leadership in the DOJ had instituted and intend to institute, particularly on the appeals process, even in the filing of cases later on, Your Honors. We think that there would be ways by which we could address such a huge number of complaints that may be coming up our way in respect to the implementation of the mandate of the NTA. But as I said, it will be a huge challenge, but the department will always try to do what it can, if only to promote and protect our needy citizens.
Thank you. Yusek, sana lahat po ng public servants sa Pilipinas katulad po ninyo na positive spirit po. And we're all, to be honest, all of us experience tremendous amount of work, no, as public servants. You're absolutely correct. I think no agency in government right now is not experiencing voluminous work from our constituents, basically. My next question is the powers, USEC, no? And you've heard comments from the from the BIR and also from the BOC. And do you see any conflict in the powers that the law aims to give the National Tax Advocate, especially, for example, on the stay order and also on representing taxpayers? The other one is issuing taxpayer assistance order. So we have included several powers, no, outside of the usual advisory powers. But do you see any conflict, for example, with the tax collecting agencies, also with the the other agencies such as the ombudsman, in the powers that we have given to the NTA?
Uh, Mr. Chairman, if we are to dilute the powers of the NTA and simply relegate it to an advisory function, it may lose its meaning and its purpose of being. We need to temper the powers that the Senate, that Congress may wish to grant unto it. But at the same time, we have to be aware as well that all the remedies mentioned by the BOC and the BIR are internal remedies. Here comes a body which is independent and which is outside of the influence, if I may say, of the DOF, the BOC, and the BIR, who can then give honest to goodness, impartial, direct, and relevant assistance to the taxpayer. It would be a classic case of the taxpayer on one side and the taxing authority on the other. And taking away its powers may prove to be making it virtually irrelevant. It's gonna be, to my mind, it may look as if it's just dressing up and making ourselves feel good about it. We have to bite the bullet, so to speak, in respect to certain strong powers, give it teeth and relevance in order for the NTA to perform its task of protecting, promoting, and guiding our small taxpayers. Of course, the matter of the stay order, that one is really a big, big issue to the taxing authorities, because virtually presently there could be major changes, major shifts in focus if a separate agency, a separate body like NTA could issue by way of administrative processes a stay order to stop the collection efforts of the government through the DFA and its tax collecting agencies. Presently, I understand, as mentioned by my friend DEPCOM Marisa Cabreros, that only the courts do have that power now. And perhaps in the reassessment by the Senate of the different powers that they initially granted the NTA, you may consider that aspect about the stay order, because anyway, if the DOJ would be there to render assistance to the NTA, perhaps the prosecution attorneys or the PAOs, public attorneys, lawyers could assist in seeking relevant remedies from the courts. I really don't want to hazard any remedies at this point, because all cases, all tax cases are determinable based on the special and peculiar circumstances of each case.
Thank you, attorney. Thank you for that. I think you made a very strong point of making it relevant. No, um, our fear is to allocate money and just to come up with an office that is not functioning or not relevant. No, I think that will be a sin to our taxpayers. No, because we aim to create an office to protect them. But if we, I appreciate your point that if we dilute their powers, it's actually disservice to our taxpayers because we're creating an office that is useless to them. No? So I see your point, and that's very relevant. Yusek, any improvements that you can suggest outside of the proposed measure? Any improvements on the NTA or any improvements on the entire bill through the lens of DOJ?
Um, we wish to be given more time to take a closer look at the provisions and try to integrate the other remedies that internally are available in the BOC or the BIR, for example, Your Honor. The It's not impossible to refine the present powers of the NTA or to integrate it, make it harmonize it, if I may say, with the powers internally that are available. Because there was a mention earlier about a consumer service unit. That consumer service unit may be an internal matter, but our concern is that it would still be an internal issue within the tax collecting agency, BIR or the BOC. It's high time that complaints offices should be outside of the entity that it's complained about, because basic due process, basic partiality issue, basic social relationship would prevent an honest to goodness determination of certain complaints against erring officers or employees of an agency if it would be heard by internal by officials that are internal or that are members of that agency itself. We have to look at things in order to make from the lens or from the perspective of an outsider, if only to be able to give impartiality and fairness and justice a better chance at getting an acceptable result. But with your suggestion of asking us ways by which the law could be improved, may we be given more time on that, Your Honor, in order for us to give relevant suggestion on the matter.
Thank you, Yusek, and we would really greatly appreciate comments from the DOJ, considering that DOJ will be an important office in this proposal. So we will await your suggestions, and if you have any more refinements to the bill, specifically the NTA, feel free to articulate it in your position paper. Thank you,
Thank you very much, Your Honor.
Thank you, and we call on Yusek Ernesto Perez of the ARTA. Yusek?
Where the stand in the matter is we support the pending bill, except that uh, the Anti-Red Authority, as the primary agency under the Office of the President, tasked to implement and oversee the national policy on anti-red tape and ease of doing business. Our concern is that to avoid the overlapping regulations, the taxpayer is not entirely without courses or defense by seeking assistance to either or filing its complaint or complaints to the Anti-Red Tape Authority in case of red tape issues, or to the Office of the Ombudsman when it comes to anti-graft. That is our concern, Mr. Chair. Also, we have issued a circular requiring all government agencies, including the BIR, to strengthen their complaints mechanism by setting up a complaints desk, as well as set up a committee on anti-red tape by the agencies concerned. We also have programs like the Zero Backlog program, and then the requirement for all agencies to submit to us their updated citizens charter, so that all services that they rendered must be disclosed, in which the public has access to. So therefore, if a citizen feels that he has been aggrieved by reason of red tape or failure of the Bureau of Internal Revenue to act on his application or process within the standard processing time, the law empowers the Anti-Red Tape Authority to investigate. And then after due investigation, to file the necessary complaint either with the Office of the Ombudsman if it involves both criminal and administrative, and with the Civil Service Commission if the erring government official uh, violates an administrative or is holding a salary grade 26 and below, Mr. Chair.
Thank you, thank you. Yusek, how do you see this bill improving um, the processes and hopefully eliminating red tape in our country? No, I'm also a advocate of eliminating red tape. I think red tape is the biggest evil of our country in terms of business processes and even simple processes for our constituents. So, how do you see this bill improving the processes and thereby eliminating red tape in our country? No, specifically, I think specifically here it is the tax paying process, no, as well
Yes,
as
sir.
the customs process.
Mr. Chair, under Section 17, subsection G of Republic Act 11032, the Anti-Red Tape Authority is empowered to review proposed major regulations of government agencies to use submitted regulatory impact assessment subject to proportionality rules. So it is now a requirement for all government, including the BIR, that any proposed regulation or even regulation for implementation must be subjected to that management tool which we call regulatory impact assessment to ensure that that regulation has been subjected to proper consultations to ensure that the regulation does not cause undue burden to or to not only to the agency but even to the transacting public. And we also have the power to recommend policies, processes, and systems to improve regulatory management in the country to increase productivity, efficiency, and effectiveness. At present, Your Honor, ARTA is being supported by the National College of Public Administration of UP, and we're crafting a national policy on regulatory management system. All of this will ensure that government processes are streamlined and automated in line with the direction of the President that government processes must be not only automated but even streamlined. Also, we're conducting business process mapping of government agencies, including the BIR. Look at their processes. This will ensure that the processes of the BIR are not burdensome, and we can even recommend certain requirements that can be dispensed with to ensure that the process are properly streamlined, Mr. Chair. And we can check this, and ARTA is also launching the report card survey 2.0. We're doing pilot testing next week. This will also give the applicant or the taxpayer the opportunity to rate the government agency concerned with respect to their experience. So if a taxpayer feels aggrieved, supposing in their dealings with the government, that taxpayer will be even have the opportunity to rate the agency by way of that report card survey that we are unifying and we are being aided by independent third party and also aided by an expert. And we have released a circular for that matter, Mr. Chair.
Yusek, do you have that rating with you right now? In your most, I know that ARTA releases ratings of government agencies. Do you have the most latest with you right now?
We do not have that rating yet, Mr. Chair, because we're just doing the pilot testing next week, and hopefully within the year we should be able to rate the priority agencies, and BIR will be one of them, Mr. Chair.
Yeah, I think in the past you have released through a press release or through the internet the most
Yes, Your Honor.
complaint agencies.
Yes.
I think.
That
Yeah.
is,
Can you?
That
Sige
is
po,
being
go
done
ahead.
by the Civil Service Commission, Mr. Chair, where they have the most complaint, but that has been taken care already by the assumed already by the Anti-Red Tape Authority, and we will be able to rate the agencies as to the number of complaints against the BIR, against the Bureau of Customs. We should be able to submit that to the committee, Mr. Chair, but at the moment we're not prepared for the updated rating or a number of complaints against the BIR.
Okay. Well, with all due respect, no, to the BIR, we saw in some news reports, and this is from ARTA, that BIR uh, is the most complaint agency, no, from the ARTA report. This is in 2001 with 92 complaints, no, and well,
2020.
again, with all due respect to BIR, I am since this is reported to ARTA, I would assume these are all process complaints, no, and we'll take this as an opportunity to improve. That's why we're here, no, discussing this bill because obviously there's room to improve from our collecting revenue collecting agencies, no. So just submit to us, USEC, but the list, the last, siguro, the last 5 years, if you have that list of most complaint agencies or any rating that you have conducted in the past so that we will have an idea on where to improve.
We will submit to the committee, Mr. Chair.
But is this accurate po in 2001?
That is not maybe 2021.
2021? Yeah,
2021.
2021. Tama po ba?
We'll check, Mr. Chair.
Kasi we saw this in a news report, no? So, all right. Thank you. Thank you, Yusek. We'll go to the private sector for now. We have a few more government agencies, but we'll go to the private sector so that our discussion will be holistic. We'll call on TMAP, who is a valuable contributor to a lot of our proposed laws. So we call on Attorney Dawilan of TMAP.
Thank you, Your Honors. This is full view from the Tax Management Association of the Philippines. I just would like to manifest that TMAP fully supports these bills that are promoting the recognition and protection of the taxpayers' rights and also creating the office of the taxpayer advocate. We in fact commend the authors of the bills as we believe that these pieces of legislation will help enhance tax administration, which would eventually promote better taxpayer participation and taxpayer compliance. So, and at the same time, these bills provide mechanisms for the protection of the rights and welfare of the taxpayers. We had actually previously provided some inputs on this taxpayers' Bill of Rights, and we are very grateful that some of our proposals were considered and are now part of the bill, especially Senate Bill number 1199. So in terms of preference, we prefer SB number 1199, not only because some of our important suggestions are already part of it, but it is also more comprehensive. At this point, we do not have comment, but we are very much ready to help enhance the bill if needed. And I hope the committee can still accept our suggestions. Thank you very much.
Thank you, Attorney. Definitely, we will welcome any more refinements to the bill. And you're correct that I understand that this bill has been, or this bill was filed, tama ba, Comsec, 8 years ago? The first iteration of this bill was 16 Congress, I think, and it went through many refinements, many improvements. Every time that there was a hearing, they would request for position papers, and the refinements will be included in the bill. So definitely, the TMAP comments were already factored in the bill. But if you see any opportunity to improve, will be highly appreciative of any improvements. Attorney, I have a few questions from TMAP, no, in regards to if you because the bill also has taxpayers' right in criminal cases, and then we also have taxpayers' right in civil tax cases. Do you see this necessary, attorney? Do you see this do you see this necessary to include two sections in the bill?
Yes, Mr. Senator. We think that these are necessary, as you said in your opening statement. These are just codifications of what are already there, but with additional adjustments. But putting it in one law will, of course, make taxpayers and tax administrators aware that there is a law that exists protecting the taxpayers' rights, either in civil cases or in criminal cases. And that would make the tax authority ensure that what they are doing is actually correct, because somehow there would be some sanctions that would be imposed if they are not following what should be done for the taxpayer. So we believe that this enumeration under Section 4 is for the basic rights, the rights in civil cases and rights in criminal cases are very much important.
Attorney, as a practitioner, how do you see this law um, helping our taxpayers, specifically our ordinary taxpayer? How do you, from an operational standpoint, no? Of course, what I see the comments of Yusek Vasquez earlier made a mark on my mind that we should come up with a law that is not only good in paper, but we can operationalize it, no? And the practitioners can help, can use it to help their taxpayers. So how do you envision, how do you foresee how do you foresee this law helping our taxpayers, and how do you see this law strengthening the entire tax collection system of the country? Because it's a symbiotic relationship. It cannot not only be just on the point of taxpayers. It has to be a relationship. No? So, from a practitioner's point of view, how can this law help the practitioners?
Well, as tax practitioner and also as a taxpayer, if I know that my rights are protected and somehow there is an office that I could go to in case those rights are not protected or are violated, then I will, because I know that these are protected, and I have to comply with all my obligations anyway. If I don't, there is an office that would make the revenue officers responsible. An example for it, I just make an example. Some taxpayers now, as we see them, would just pay something or maybe underdeclare their tax payments with the hope that even if they do the filings correctly, payments correctly, there will always be an examination and there will always be an assessment. So rather than paying correctly, they would rather understate their payment with the hope that when they're examined, they will just pay whatever is lacking, rather than paying and then paying correctly and getting assessed. Then later on, you will still be assessed and pay more. But if I know that my rights are protected by this Bill of Rights, and then through the help also of the taxpayers advocate, then more or less or somehow I'll do my obligations correctly. I think that's how it should be seen, Senator.
Thank you for that. It's important also to know from the practitioner's point of view how this bill can be operationalized, no? Because at the end, I'm sure the practitioners also will be the users of this law. Another question, attorney, is the version that I filed, we also specified obligations of the taxpayers, no, to balance out, no. So meron kang rights, meron ka ring obligations, no. Aside from what is in, first of all, what do you think of that, of including obligations? These are just basic obligations, anyways. But do you see any more improvements as to the obligations of the taxpayers?
Yeah, that section providing for the obligation of the taxpayer is just actually a reiteration of, again, the obligations that are already existing under our tax code. So actually, there's nothing new there on the part of the taxpayer. Again, it's just codifying what is in the law
Okay.
already. in practice.
Do you see anything, any more improvements to this? Do you see?
As it is written now, we don't have comment or additional enhancement there, but we'll look into it.
Thank you, attorney. Thank you very much for your comments, and feel free to send us your updated position paper. As you have noticed, your position paper has been considered many times, no, in the bill. So we'll welcome any more comments on the proposed measures.
Yes,
Thank
Senator,
you.
as we are hearing from today, I think there are some things that may need really also to be enhanced or improved. Thank you.
Thank you, po. Thank you. We call on the next private sector resource person will be PICPA. We have three representatives from PICPA. So anyone from the representatives can make their comments.
May I be recognized, Your Honors?
Yes, sir. Attorney Aspe.
Yeah. I used to be with the Bureau of Internal Revenue, and I held the position of the Deputy Commissioner for Operations for more than 9 years. But because of age, I have to retire and found myself now in practice as a lawyer and as an accountant. So last July 1st, I assumed the post of the chairman of the Committee on Legislation and Taxation of the Philippine Institute of CPAs. And there's a co-chair by the name of Ms. Irie Ikaranum. She's also here with us, and two other members of that committee. May I just inform the committee that yours truly became aware of these pending bills in the matter of the taxpayers' bill of rights and, of course, the obligations only some 48 hours ago. And definitely considering that this is a matter of public importance, yours truly ask the members of the committee and all other accountants, CPAs, to make their comments on this bill. So at this point in time, I will ask or request the committee to give us a little more time, probably 2 weeks or 3 weeks, whatever it is, to consolidate our comments. But offhand, Your Honors, may I just share my own personal comments on certain things, particularly the creation of that National Tax Advocate Office, or sort of. Correct me if I'm wrong, but let me just ask. I have to find this out from the bill itself. When does the service of that advocate office come in? Is it upon receipt by the taxpayer of the letter of authority? Can the taxpayer already consult? Or would it be after the Commissioner of Internal Revenue has rendered its final decision if the case is brought to appeal or by way of a request for reconsideration by the head of the agency? Well, assuming that the intervention of the National Tax Advocate comes after finality of the assessment, then it would appear that it is an alternative to that of going to the Court of Tax Appeals. It might be good for a number of taxpayers which are avoiding the big financial bite of filing a case, sustaining a case in court. Firstly, I the, it, even if the case of assessment is already filed in court, the BIR under the law has still its powers to pursue collection remedies. And in some cases, it reaches the matter of issuance of warrants of distraints, warrants of garnishment of the banks. Of course, there is an exception whenever the court um, rules in favor of the taxpayer on a motion to set aside that duty of the BIR or prohibit the BIR from pursuing the collection remedies while the case is pending in court. But the problem there, Your Honors, is that in many situations, the court will require the filing of what we call a bond. And securing a bond right now is very costly. Well, on the part of the taxpayers, it is more favorable to them if indeed there is that office which would be an alternative to that of the Court of Tax Appeals. Well, on a very simple issue, again, some of my colleagues at the Committee on Taxation has texted me just moments ago that perhaps we can ask or request the committee through our position paper to include a provision. I'm not sure if this is already part of the of the procedures recommended by the committee to revive the mock court at the BIR whenever there is a petition or a sort of a request for reconsideration of an assessment issued by an authorized officer of the Bureau other than the commissioner. You see, we were talking about remedies, assessment procedures, and remedies of the taxpayers when we had Deputy Commissioner Cabreros during our first hour. An assessment might be issued directly by the commissioner, or an assessment might be issued by a subordinate official, and in most cases, it is the regional director. The decision of the regional director, based on a final assessment, may still be protested with the office of the regional director. And the regional director may either sustain the taxpayer's view or reiterate the assessment by way of what we call final decision on disputed assessment. The present rule is that a taxpayer aggrieved or who does not admit the final decision may either go to court or, in the alternative, go to the office of the commissioner and file a request for reconsideration of the decision of the lower official. Either. Going to court would involve the payment of docket fees and other, incident expenses, lawyers, etc., research, etc. But going to the commissioner can be done under our present law by way of a request for reconsideration of the decision of the lower official, in which case the commissioner, under present rules, refers the case to the legal group, and the case ultimately finds itself to an office which right now is called the Appellate Division at the BIR. Well, my friends at the Committee on Taxation prodded me to make this request that if the Appellate Division through the Office of the Commissioner revives that having a mock court whereby the examiner and the taxpayer himself would present their respective evidences administratively. Well, chances are that the case might be solved without going to the court or any other arbiter for that matter. It's not present nowadays. Well, that's another issue. There are still parochial issues which the committee, the tax committee of PICPA will try to discuss and have it submitted to this committee of Senator Gatchalian, and what's one of which is well, again reiterating that books of accounts submitted by the taxpayer to the examiner are still properties of the taxpayer, and therefore after they have been examined through to the satisfaction of the examiner should be returned to the taxpayer. There are complaints like that. So there, your honors. There are a number more, but at this point, I shall be asking my committee members and the other practitioners at the Philippine Institute of CPAs to send us their comments or suggestions which are relevant to the bills being taken care of. On the part of the Philippine Institute of CPAs, well, there is that accreditation requirement among accountants. They are already accountants, but there are still those who are required to secure accreditation as professionals and do practice of their own. And, well, of course, continue with their studies about subjects which are relevant to their practice. And one of which is that of being uh, an auditor, an external auditor, and to some extent to be an accredited tax practitioner. We will look into this. We will look into the status and course updates on what have PICPAs been doing with the accreditation procedures. Your honors, fellow taxpayers, I take this time to give thanks for having the Philippine Institute of CPAs in this very important hearing. Thank you again.
Thank you. Thank you, Attorney Aspe. Attorney Aspe, when was that mock court last operationalized?
I would assume about 20 years ago when I was new in the BIR.
Kaya pala ho, alam nyo, tatlo ho yung CPA sa likod ko. Tinatanong ko ho itong mock court, hindi ho nila masagot-sagot eh. Kasi mga 30 years old lang ho itong mga ito. Nung 20 years ago, mga 10 years old lang yata itong. No, but no, that's why I was asking actually I have 3 CPAs sa likod ko ho, attorney. So I was wondering when was that mock court last operationalized. I think it was a long time ago. But I get your point po, Attorney Aspe, about the mock court, and we'll take note of your comments. Attorney, you mentioned earlier that part of the redress mechanism inside BIR is they can appeal to the regional director, and the regional director can either sustain or take the position of BIR. Also appeal to the commissioner you mentioned earlier. But how often, in your experience as a practitioner now, how often do the BIR regional officers and also the commissioner take the position of the taxpayer. No? Of course, that remedy is available. No?
Yeah,
That
you're right.
redress is available. But how often do the taxpayer actually win their appeal? No?
Mhm. Well, Your Honor, let's say that whenever there is a new decision by the courts, um, more often they are the ones well advanced by the protesting taxpayer. So there's no other sort of decision but to um, uphold the decision of the court in similar cases, and if it is um, beneficial to the taxpayer, then it is granted. After all, the basis is there. Or if it is a matter of factual issues, then the director gives in to the request of the taxpayer or that of or the commissioner through the appellate division decides in favor of the taxpayer, either partially or entirely, if the issue um, is pertaining to all matters at hand. So nananalo naman po.
Thank you, Attorney Aspe. I'll make sure po itong mga CPA namin nagbabayad po ng dues sa PICPA. No, baka hindi ho nagbabayad ng membership dues ho to eh. No? But thank you, Attorney Aspe, for your participation.
We have several seminars, Your Honors. Seminars for them to have their continuing professional education, and more often to let them know of what's happening. You see, number one strategy in revenue generation is educating the taxpayer and their agents. So that's all, Your Honor.
Thank you, Attorney Aspe. We call on PCCI, represented by Attorney Carlos Carrado.
Your Honors, members of the Executive Department, our colleagues from the private sector, good afternoon.
Yes, we can hear you, Attorney. Go ahead.
Has no official statement yet on this proposed laws. We came here to see and understand the policies underpinning these proposed bills, and therefore we would continue to work with your honors and our and the other stakeholders to fine tune this law. The PCCI tax the PCCI tax advances the interest and welfare of our of the different businesses and industries within the Philippines, and therefore laws like this with national implications, we would surely try to be involved. Just the same, I'd like to note that the creation of the National Tax Advocate, I may at this point share the view of DEPCOM Cabreros that it may not really be necessary, but just the same, we would want to keep an open mind and probably hear later on some more of the positive points if ever that position, that NTA would be created. Because personally, I think that may just add another layer or duplication that would further detriment or be adverse against the taxpayer. Because currently, for example, I'm not sure if there's anything other than our courts that would reverse the action of the BIR. I would note that the provisions of the current bills while trying to capture the rights of the taxpayers, also focuses more on the creation of the NTA. So we at PCCI would probably want to see more uh, specific and more direct statements enshrining the rights of the taxpayers. While I would note that these statements could be further enhanced and improved so that specific areas in the tax landscape could be improved. For example, uh, like the BIR is tasked with crafting laws and regulations, but sometimes there may be a need to, for example, mandate the BIR to release for public consultation certain revenue issuances to avoid confusion. Um, sometimes that really happens in the areas of tax assessments, for example, while the taxpayer may have the right to be assured that everything is going according to the current rules, probably some areas may be codified, for example, preventing the Bureau of Internal Revenue from going to social media, for example, and mentioning specific persons, just those companies simply because those companies failed or still refuses or probably went to court and refuses to pay tax being assessed against them. So those things. Also, for example, while there are specific rules, um, sometimes they may not be really working very well for the interest of the taxpayer. So, like these days, when you are encountering a final decision from the BIR, sometimes there would be writs of garnishment being issued against your bank accounts. But then technically, that shouldn't happen because if you have appealed your case to the Court of Tax Appeals, then there is no basis for the BIR to do that. But just the same, we have seen instances that these are happening these days. And unless the taxpayer would really have the resources to go to the Court of Tax Appeals and have a stay of the writ, then if it's just a simple taxpayers, then what else can happen, right? So there are specific instances where we can probably put more teeth to the law, not really letting our government agency to put more specific details into the law, but rather for certain important areas where we can already codify them affecting different areas of the tax landscape. With that, Your Honor, PCCI wishes to thank the committee to be invited in today's hearing. Thank you, everyone.
Thank you. Attorney, in the absence of an official position from the PCCI, but after hearing the discussions earlier, can this bill help our businessmen? Because PCCI obviously is the organization that represents the business sector, no? And can this bill help our businessmen, our entrepreneurs, and how can this bill help our entrepreneurs?
Yes, Your Honor. I can, while I mentioned that I share the BIR's viewpoint on the possible duplication and probably usurpation of powers by this NTA, I also share the view that maybe with some refinements, this could work. So, especially for the small taxpayers. But then we really need to define and discuss the parameters, just like Attorney Aspes comment on at one point when will this NTA involvement kick in, right? And at what capacity can they stay any assessment from the BIR, or will they just be recommendatory? So, but then again, I also see the point where the NTA, if you have a small taxpayer that doesn't have the resource, the money to hire lawyers and CPAs to advance their cause, then just like you have POW for your normal legal cases, then probably we can entertain having this CTA as an entity or a branch that would take the interest of the small taxpayers to heart. So yeah, I guess it all depends on what the succeeding discussions will be. And therefore, PCCI would really want to be more involved in this discussion, Your Honor.
Thank you. Thank you, attorney. Thank you for that. The next will be the uh, BS Med, represented by Ms. Susan Salonga. Ms. Susan Salonga. Nandiyan po kayo, BS Med. This is the Bureau of Small and Medium Enterprises Development. Yes, Ms. Susan, any comments po?
Mr.
Kain na
Chair,
yata si Ms. Susan.
Mr. Chair,
Yes.
magandang umaga po on behalf of the BISMED, that is the bureau under the Regional Operations Group, DTI. If
Okay.
I may, can I just make our short comment, sir?
Yes, go ahead, DTI. I was going to call you also.
Yes, sir.
Asek, go ahead. And you
Yes,
can
sir.
represent the BS Med. Go ahead.
Yes, sir. The department support the proposal which grant the needed assistance to the MSMEs in the meeting their tax obligation and receiving the benefits and credits they are entitled to. This will be optimistically lead to a higher compliance and better revenue levels for the government, which will provide for a better public service. With due respect, Mr. Chair, allow me to have our comment on certain provisions. Our comment and recommendation. The Office of the National Taxpayer Advocate is recommended to be an independent and autonomous office attached to the Department of Justice instead of the Office of the President, as it deems fit to the role as advocate for equal access to justice as proposed in the Senate Bill number 1199, authored by your Honorable Senator Gatchalian, sir. The proposed section is also welcome provision considering the significant contribution of MSMEs to the economy. However, in order to be truly effective, increasing an understanding of a wider tax base is essential. We propose inclusion of earnings individuals identified as person with disability, senior citizen, pregnant women, to be similarly prioritized in their application for the issuance of the tax assistance order. And lastly, Mr. Chair, the micro and small taxpayer clinics services are prepared to be free of charge. It may also indicate a limit on the allowable charges that the taxpayers may incur in availing such services. Scheduled and minimal fees for be identified in the Act of Implementing Rules and Regulation depending on the type of services being availed. And lastly, sir, we would like to request taxpayers' bill rights and obligations should be made available in every revenue districts, revenue regional offices, and collection district, and the National Office of BOC with regards to MSMEs. I suggest a massive information campaign of the Taxpayers' Bill of Rights and Obligation and cascading of information down to the barangay and the Barangay Development Council and collaterals issued the awareness of our constituent of the local level. With that, Mr. Chair, we submit and support this proposed bill. And congratulations, Mr. Chair. Thank you.
Thank you, Asek. Thank you very much for those comments. Asek, since you uh, uh, liaise and interact with our MSMEs on a regular basis, what are the common complaints, common requests of our MSMEs insofar as tax paying is concerned, is insofar as importing goods is concerned, so that we will know if the bill will address those complaints and concerns that they have.
Sir, thank you. Number one, the awareness of our micro MSMEs taxpayer. Number two, the identified level of income of the micro businesses. And then number four, they want a full support from the local government unit for the implementation of these micro taxes to our business entrepreneurs, sir.
Can you elaborate further on the identified income? What do you mean by identified income?
Sir, the micro MSMEs, of course, we have the 3M minimum. But for the lower income generating micro MSMEs, what will be the amount that will be included to be paid in terms of tax payment for the micros?
But what are the what's the common issue that they encounter in terms of tax paying? Ano ba yung mga common naririnig niyo po? Because I'm interested in that. I want to juxtapose that with the bill that we are discussing. If the bill can address those issues.
Sir, yung ano lang talaga, yung number one, yung awareness po para dito sa mga magbabayad sa taxes. And kailangan lamang po talaga ay ulit-ulitin natin sila na mabigyan ng information dissemination. And yung cooperation po ng ating mga barangay officials, importante, as well as yung mga local government offices po, LGUs, yan. Yan lang man ng usual. And siyempre, isang complaint, sir, ang katotohanan, ngayon pa lang daw po sila nakakabangon at sana by the time na dumating na po itong bago nating bill ay nandun na po sila sa naka-rebuild na po sila ng kanilang ekonomiya at hanap buhay.
Thank you, Asek. Thank you for that, and thank you for echoing the sentiments of the DTI. And last on my list is Attorney Bokar of the Privacy Commission, National Privacy Commission, for their comments.
Thank you, Mr. Chair. On behalf of the National Privacy Commission, we welcome the new bill regarding the taxpayers' rights. We also welcome the provision on outlining the right to privacy. And we just submitted our comments earlier this morning that we wish to probably relate in the later discussions. The rights of the data subjects that are also included in the Data Privacy Act, some of which relate to the confidentiality and the non-disclosure of the taxpayers' proceedings if there will be, if there were to happen. So we look forward to some of the comments as well relating to the Privacy Acts and as including the rights of the data subjects as well, along with the rights of the taxpayers in this pending legislation. So that's all for now, Mr. Chair, and thank you.
Thank you for those comments. I have already exhausted everyone on my list. Are there any more comments or reactions to the comments, no, of our resource persons? Feel free to let us know what are, if you have any more thoughts on your on the bill that we are discussing. Yes.
Mr.
Sec-
Chair, if I may just add a few comments. I observed that in other jurisdictions, the availment of the services of a national tax advocate, which for example, in the U.S., is an independent body, but within the IRS. They have certain criteria on which these services of this advocate can be obtained. In our bill, it appears that there is. I was scanning through the different provisions, but did not see somehow a sort of a qualification on how the services can be availed. Perhaps it can be limiting. There may be a limiting provision on how and who can avail of these services of a tax advocate. Also, I observed under Section 20 of the bill, the DOF is mandated to create a sort of an office that will provide assistance to different MSMEs in their cases with the BIR. We just like to revisit this, Mr. Chair, as this may be run contrary to the mandates of the DOF as a supervising agency of the BIR and the Bureau of Customs, which are also mandated to pursue with zeal the collection of taxes within procedural and legal means. Creating a counter unit that can advocate for the other side, the taxpayers, maybe transferred to that and advocate's office if that's all our concerns, Mr. Chair.
Thank you, ASEC. As to the people who can avail of the services of the advocate, in Section 14, we actually place there a prioritization. And let me just read. Application for the issuance of taxpayer assistance order filed by individuals earning purely from compensation, from practice, MSMEs, shall be given priority. So, in a way, there's a prioritization, but we're open to suggestions.
Yes,
If you-
Mr. Chair, because if you look at the powers of the tax advocate, it under A and B of that section, it has all the possible powers that can exercise, and it can be either exercised by or be made use by the tax advocate to taxpayers that are MSMEs or large taxpayers or medium taxpayers for that matter. With the Section 14 deals with the TAO, Tax Assistance Order, which has a criteria for application. And there, I think there's a different section where there is really an instance or two instances whereby the TAO can be issued. So with respect to other services such as those enumerated under Section A and B of of powers of the it can be availed or applied with the different taxpayers, Mr. Chair.
Thank you, ASEC. I get your point. Yeah, well, we're open to suggestions. Again, that's why I asked the DOJ that this will serve the taxpayers who are, I would say, who cannot afford legal services as well as accountancy services. So there will be in the realm of probably ordinary taxpayers, probably in the realm of small to medium size, no? Typically, these are entrepreneurs, no? Although they're exempted from paying VAT, no, if they're below 3 million, but if they go above that, they have to already start filing all the requirements, no? So, and also, um, some of the taxpayers who are availing the graduated income tax levels, no, uh, uh, the tabular levels, those are also affected, no. So we're actually looking at those type of taxpayers. So, but having said that, yes, we welcome any suggestions. If you feel that we should limit that, we're certainly open to suggestions. Insofar as the clinic is concerned, yes, we're also open to suggestions with this. This will be established by the DOF, but if the DOF feels that this is already or can be embodied under the advocate, we're also open to that suggestion. If you look at the entirety of the bill, it's really driven. It will be DOF driven, and so we'll appreciate it if you can give us more comments and refinements on the bill. No? But generally, what I hear from our source persons is they support the bill. Of course, we will take into consideration some of the issues, especially on the advocate, as well as potential redundancy and potential usurpation of powers. We'll take note of that. No? Yeah. With that, any more comments from the body? If we have any. If you, yes, from the body. Um, if there are no more comments, we'll request just a few requests. Number one is from Arta to give us some of the rankings in terms of complaints or other type of metrics. Please give us those agencies for the last 5 years. And we would like to request everyone to submit your position papers to us on or before September 20. We're scheduled to have a technical working group by September 22 on this matter. No, that's a tentative schedule, but that's the target schedule. And if there are no more comments from the body, I would like to thank everyone for your time, for your honest comments. I would like to thank everyone for your participation in this bill. Like I said earlier on, we are all beneficiaries of this bill because we are all taxpayers. And let's give this bill a lot of attention and thought, no? So that we can refine it and help protect our taxpayers. So again, thank you very much for your time, and we'll await for your position paper. Again, submit it to us on or before September 20. So this meeting is hereby suspended. Thank you.
Thank you, Mr. Chair. Senator.
Thank you.
Thank you, Senator.
Dominic, glad to see you here.
Nice to see you here too, sir.